Okay, good afternoon, everybody. As has been said, I'm today going to talk to you about national trials, a little bit about what's been happening with the trial and next steps for the trial. But before I talk about next steps, I'll take you back to why and when they began. So I'll start with a very short recent history lesson. So if we're looking at the background to the trial, so what I've said is the rationale, so the reasons behind starting the national trial were just as I have set out on the slide there. It was created to provide children and parents and young people with that option to have that single point of access to challenge and resolve the educational, health, and social care parts of the education healthcare plan, where previously it had only really been in relation to educational aspects. So this was to provide an opportunity of, instead of you having to navigate the tribunal process for education, and then on top of that, enter into various long-winded routes of complaints processes of the different social care and medical divisions, this was to provide a one-stop shop to the process where education, health, and social care needs and provision were to be addressed all at once. So if we're looking at what the aims for the national trial were, so one of the stated aims was to create what we call a more holistic view of the child or young person's needs. So it was to draw up a complete picture of needs. It was also set to unify appeal rights. So as we see, the plan deals with all three issues. So why not the procedure through which to challenge its content? It was hoped that this would also encourage joint working between the different departments. And then, as a result of that, it was also hoped that all of this would bear positive results and more satisfactory results for families. So the question came, how was this to be done? And that's when we had the pilot. So this idea of that single point of challenge was put into practice through the pilot. And that pilot scheme took place for 15 months, from June of 2015 to August of 2016. Now, 17 local authorities took part in this. There were only 30 appeals, and of those 30 appeals, only 9 went to a hearing. But even from that low number of hearings, it was clear from a number of individuals using the process, including parents and the local authority, that they did support the principle of using this one route to address issues within the healthcare plan. However, as you can see, that out of those 9 hearings, there wasn't actually enough data to have a comprehensive assessment of the impact of the trial. The responses to the recommendations from the tribunal, you couldn't work out whether they were helpful yet. And they couldn't really identify, based on those 9 hearings and 30 appeals, whether it was generally a success or failure. And that's why the trial started. The trial began, and it was set to be a 2-year trial. It involves, it's still going on, all 152 local authorities and the clinical commissioning groups for health matters. It followed the same principles as the pilot, and although it was set to last until the 31st of March of this year, it has actually been extended until August of this year. So there are another 3 months officially left of the national trial. Now, the powers that the tribunal have in relation to issues on the national trial are contained within the 2017 regulations that I've set out there. And those are that give the tribunal the power to make what we call non-binding recommendations about health and social care needs and the provision to meet those needs. The powers are non-binding because, as the name suggests, it's only a trial to test whether the national trial would work. So the government didn't want to have powers set in stone and make the decisions binding without knowing the knock-on effect of the use of those powers. But of course, there has been a strong expectation that the recommendations from the tribunal will be followed. And then there's the opportunity, if necessary, for you to complain to the Ombudsman and or seek judicial review, so take a challenge to the court. So what can the tribunal recommend under the national trial? So where the case is regarding a refusal to refusal to issue an education and healthcare plan, if the tribunal then go on to order that a plan is to be made, it has the power to recommend that health and social care needs and provision be specified when the plan is drawn up. Where health and social care needs or provision are not included in the plan, and you make a request for them to be included in the plan, the tribunal has the power to recommend that those suggestions are specified within the plan. Where health and social care needs are already in the plan, then the tribunal has the power to recommend that the needs or provision are amended within that plan. Of course, as all of us have been saying, any recommendations or orders from the tribunal will need to be based on the evidence that is provided and presented to the tribunal. I often get the question about who exactly will be or has been making the decisions at the hearing. Well, firstly, there is a qualified judge who is a lawyer and obviously trained in the relevant law and with experience of deciding these cases. But that judge also sits alongside one or two specialist members. So these individuals will have a health and or social care background and will be trained in special educational needs and disability law as well. And this is why you're often told that they are an expert and specialist tribunal. So the Department for Education predicted initially that there would be only about 350 cases on the national trial. However, figures from when the trial began, from April of 2018 until the 11th of May, so just last month, there have actually been 1,956 cases on the national trial. And those cases on the national trial have represented about just over 1/5 of appeals in general. So that was the overall figure to May. But if we look at appeal applications that progressed up until January of this year, there were 1,590 applications up until January. And 75% of those applications were dealing with children, and 25% were to deal with young persons. Out of those, 838 dealt with health and social care, 354 dealt with just health, 310 dealt with just social care, and then 88 became education-only appeals. From these figures, I think it's clear that there hasn't been the use of the national trial that there could have been. I think that there are probably quite a few more cases that were crying out for some social care and or health input within them. Now we get to the actual trial and the additional considerations, because of course previously we had appeals just dealing with education, but these additional powers, as I've said, can deal with health and social care. So this is in relation to Section C, description of health needs related to special educational needs. And when we say description of health needs, This isn't just limited to listing any diagnoses. Your requests in this section should include descriptions of how health conditions affect and impact on your child or young person on a day-to-day basis. And then there's section G, which is any health provision that's reasonably required by the learning difficulty and or disabilities, which result in your child having special educational needs. It also can include long-term conditions, for example, which need management in the educational setting. So I come on next to some of the reoccurring issues in relation to health that have been happening within the tribunal. For example, there have been assessments from mental health services. So for example, whether they should be happening or how the recommendations from those reports should be put into practice. And one common thing that keeps coming up in tribunal is in relation to cognitive behavioural therapy. Sometimes this can already be agreed before the tribunal and ends up either in health section or the educational provision section. But there is often an argument when if it gets to tribunal about where it should be within the plan. For therapy such as cognitive behavioural therapy, the medical aspect of it in relation to addressing mental health issues is clear. But there is also the fact that therapies such as CBT can educate or train a child or young person to manage, for example, their anxiety. So this can be considered as special educational provision, and therefore you can request that it is in section F of the plan. This will ensure that the local authority with its educational hat on is responsible for providing this therapy. You can see on the slide there that the issues of occupational therapy and physiotherapy assessments and provision also come up. And this is a similar issue as I was talking about in relation to CBT. So whether it can be regarded as health and or educational provision. Much will depend on the context, but there shouldn't be blanket policies from local authorities which place, for example, occupational therapy in the health section or in the education section without proper consideration of what that provision is. When reading assessment reports that have been provided, the programme suggested by the occupational therapy and physiotherapists have elements of education and or training in them and are designed to make sure that your child or young person can access and meaningfully engage with education. So that would tend to suggest it should be within section F. And because of this, it's important that the expert reports that you commission should set out the education and or training aspects of the provision that is required and recommended. You can see on the slide there that also the issue of nursing support can come up in tribunals on the national trial. For example, this could be how that nursing support may be integrated into the school day. For example, things to do with training for teaching and support staff in tracheostomy management and care, or whether there is a need for a nurse to be on site with your child. So those are just some of the recurring issues in tribunal. If we move to social care, there the tribunal can look at section D of the plan. So that's the description of social care needs related to special educational needs or disability. And then we have sections H1 and H2. Section H1 is the social care provision which must be made for the child or young person under 18, resulting from the Chronically Sick and Disabled Persons Act. What do I mean by that? So the social care services that can be provided under that Act are quite wide-ranging. For example, this can include things such as support at home, support for accessing the community, support for accessing recreational activities, respite care, even adaptations to the home. When we're looking at section H2, so that's any other social care provision reasonably required by the learning difficulty or disabilities. So that, for example, could be residential short breaks or provisions secured through social care direct payments. This section should really be setting out exactly what is going to happen, who is going to be doing it, and potentially what skills and qualifications or training they may need if necessary, how often it will be made available and when it will be reviewed. So some of the issues that have been coming up at tribunal in relation to social care, just picking a few of these, we have the issue of assessments. There can be sometimes an understandable reluctance for you as parents to request social care assessments and sort of get social services involved. But sometimes this request can be beneficial because it can result and may result in qualification for services from the local authority that can benefit the whole family. One example of this is respite. However, in these tribunal situations, it's not uncommon for you to get a response from the local authority saying not known to this service when they've considered social care assessments, and then there is nothing further. That is not an acceptable response as part of their assessment duties. But if there is that response, that often means that you having to engage potentially an independent social worker. I think we've had questions on the thread about how to get an independent social worker. As a starting point, I would suggest that there's the British Association of Social Workers, which has a directory of independent social workers and a list that you can have a look at there. But to supplement a social worker's report, or if you don't have the social worker's report, then providing your own evidence on social care aspects is helpful. I think, as Charlotte mentioned earlier today, evidence from you as parents and carers of your children can be extremely powerful. But as well as your evidence, there can, in relation to social care, also be evidence from teachers, any youth workers, and it can also feed into reports from occupational therapy and psychologists that you may already have obtained. If there isn't enough evidence about the specific social care provision, but there is a clear need for social care provision, sometimes you can get to a hearing and the tribunal makes a recommendation that a social care assessment should be happening and can set down a timescale for this to be happening. I think we've had questions about what happens if the local authority does have a social worker report and you as parents also have a social worker witness. Then that goes through the usual process of questioning at tribunal with both social workers providing their evidence, and then it would be up to the tribunal panel to make their decision and the recommendations after hearing from all of the witnesses. Just picking another point from the slide, social workers' contributions to the EHCP review and planning meetings. Essentially, this is that the assessing social worker should be attending and contributing to the EHCP reviews and planning meetings. Here at the bottom of the slide, we've got residential placement versus alternative education and social care packages. So this is, for example, if you are suggesting that your child should be going to a residential placement to meet their needs, and then the local authority suggests a college on top of a supported living placement with wraparound social care and support workers. But there, I think is really going to have to be looking at whether your child's needs can be met under one roof in the residential placement, or in the sort of more fragmented way of the college plus wraparound care. So those are just a few of the issues that have been popping up in tribunal, but the question is it working? So partly, yes. In lots of ways, it has been. You saw at the beginning of the presentation the aims that I described that this trial was supposed to be meeting. The national trial has been used effectively to resolve disputes in all three areas, so education, health and social care. So that desired joined up approach to challenging the plans is working. It's allowing you to avoid, in lots of ways, the three-way complaints process. In many ways, there has been a whole holistic assessment of children and young people. There are many cases which don't actually reach tribunal because there's been that coordinated approach to assessment and planning. So it has worked effectively at an early stage to reach settlement. In some cases, it has been forcing the gathering of relevant evidence and explanation because it will be before the tribunal panel. So another objective is being met, and there is evidence of collaboration and joint working within local authority departments, as well as with the health organisations. But I think we have to accept that the extent of that cooperation does vary between local areas. In some cases, it can act as an instigator for earlier consideration of cost arguments. Sometimes this being on the national trial and having that holistic assessment and thinking about education and social care needs and having to put costs together for that, can make the local authority really weigh up the costs of provision across the board to make informed decisions about whether to challenge or concede. And going back to the example of a residential placement versus the college and social care wraparound care, I have had cases where you do look at the figures closely of the local authority, and there clearly isn't the cost difference that has been suggested. In cases, I've had the local authority's costs being greater because of the different sources of provision that they are having to arrange, instead of having the care under one roof. In those circumstances, the local authority's unreasonable public expenditure arguments really don't work. But for as much as the national trial is working, there are unfortunately ways in which it isn't working. There is the fact that you fall out of the appeal system, the national trial, if you resolve the educational aspects of the appeal. Therefore, there is a need for there to be an educational complaint, so aspect to your appeal, in order to continue with social care and health elements. And so that kind of defeats the object of having that one-stop shop approach. And as I've said, another problem is that some local authorities simply do not have that coordinated approach. It's not joined up still. As you've heard from John, adjournments were still happening. There weren't enough judges and suitable venues for hearings to be taking place. However, there is a question of, has this been resolved now? I know that more judges have recently been recruited, and wing members, so those specialists in health and social care. And they have obviously, as John was talking about, been having video hearings, and that has been successful in clearing some of the backlog. Some of my experiences of video hearings have been positive, but subject to improvements in technology, it may be a suitable fix in relation to certain types of hearings. So potentially hearings where there are fewer issues and fewer witnesses. But the national trial has also brought with it additional costs. Obviously, in lots of cases, it is a 2-day hearing, which costs more generally. The extra day, there are more issues, more witnesses, more time in terms of emotional costs and financial costs. It's known that the local authority have reasonable costs reimbursed up to £4,000, but there's no real similar support for parents and young people taking these appeals. So there is an inequality there. So where are we now? As I said earlier, the national trial has been extended until the 31st of August of this year. Research was being conducted, and I think it was potentially completed before we had the outbreak. But that was an independent evaluation of the trial, and that was in order for the government to make a decision on whether the tribunal recommendation powers in terms of social care and health should be continued after the trial ends. That evaluation, so all of that research, has included interviews with stakeholders, case study visits, so 12, I think it was 12 areas were visited to find out what their area experience was of the national trial. There have been surveys of appellants, maybe some of you have taken part in that survey. There's been an analysis of response to recommendation letters, so a review of the responses to recommendation letters issued by local authorities and the health commissioners. There's been an online survey and cost case studies, so comparing the journey of a case involving health and social care within the national trial. In terms of next steps, ministers were actually supposed to be making a decision in relation to what happens on the national trial just after Easter. However, because of the coronavirus, it has delayed this consideration of the national trial, and it's lower down their list of priorities. The June national trial newsletter, which came out on Monday, confirmed that the whole process of evaluation has been paused due to the pandemic. In any event, it's my view that it's likely that a decision will be made to further extend the national trial in the short term in order to extend time to continue the review. And ultimately, I do think that the recommendation powers that the tribunal have will be continued. And if it is, I would like to see some improvements, or should we call them changes. So I've put there orders to replace recommendations. That simply means that I'd like to see binding decisions. So to get rid of those non-binding recommendations. The relevant evidence is being gathered to support decisions. There's, as we've said, the specialist tribunal with specialist members to make those decisions. So why not make those decisions binding on parties? If they are binding, of course, it also means that a further challenge to health and or social care can be at the same time as any challenge to educational matters, rather than having to go to the Ombudsman. I've also put there that there should be freestanding health and or social care appeals. So it follows that if the tribunal can make orders, then the sole or joint issues about health and social care plan should be able to go before the tribunal without the need for an educational element to it. Improved case management. What I'm saying there is sort of better identification of remaining issues in the case prior to the hearing. So realistic timetables can be set, including, for example, whether 2 days are necessary and whether witness attendance can be split if necessary or required. Of course, it's helpful for all witnesses to be able to hear the evidence that's presented, but it may at times be more efficient and cost effective for you if particular witnesses could be scheduled for just one of those days. And lastly there, I've put more judges and more venues. I've already covered this in my previous slide. It goes without saying that adjournment's not helpful for anybody. And now the jury is still out as to whether this has been resolved in the interim period through the recruitment and video hearings. We shall see. Well, those are my thoughts on the national trial. In essence, it seems to be working. There are things that need to be improved, but it looks like the principles from the national trial are set to continue. Thank you.